I mean, very focused on what's going on, not far from my own home, but across the country. Three men called the Coutts Three are facing, well, a sentence. They were convicted of mischief for their role in the Coutts border blockade. That was in February of 2022. As you know, the main protest was in Ottawa, the massive convoy, but they were echo convoys around the country. The one at the Coutts border blockade was particularly effective because it was a choke point and it was very far away from large population centers. So there was no large local police force on the scene. Not only were there a lot of truckers who were blocking roads in Coutts, but farmers got into the action too. It turned into quite a showdown, but Trudeau used a judo move. He tried to claim that what was happening in Coutts was such a crisis that it required the country to put under a form of martial law under the Emergencies Act. That is why the Coutts Three were charged. And there's another trial of the Coutts Four. They were charged with much more serious offenses than just mischief. They were charged with conspiracy to commit murder of a police officer. Now, two of those four, as you know, took very minor plea deals, but two more of them are still on trial. The man who has been covering all of these matters for us is our friend Robert Kraychik, and he joins us now to talk to us about what's happening in Lethbridge, the city whose courthouse he stands in front of now. Robert, great to see you again.
Great to see you too.
Well, thank you very much. You have been out there for weeks now, I dare say even months, because there's two loosely connected trials. One of them has already been found that the three men have been convicted by a jury, which I think packs more punch than if it was a judge alone. That's in the more minor cases of mischief. So all that's coming up is the sentencing. But the other case, the much more serious case, those two men have been in prison, well, for about 2.5 years now. Isn't that right?
Yeah, they've been in remand. They've been in police custody since February 14th of 2022 when they were arrested.
Well, give me an update on both of these cases because similar background facts, but of course the charges couldn't be more different. Why don't you start off by telling us the latest in the Coutts Three? Those were the more minor mischief charges. The jury convicted, and now it's up to the judge to give the sentence. Let's start there, and then we'll move to the more serious case. What's up with the Coutts Three? Marco Van Huigenbos, George Janzen, and Alex Van Herk.
So there's a sentencing hearing scheduled for late August, and then a final one expected to be in late September, I think 25th, 26th, 27th. But more importantly, Marco Van Huigenbos himself did not participate in this interview with the probation officer to complete what's called a pre-sentencing report, this PSR. Now, I've come to understand that these PSRs are created post-conviction in order to create a document that judges can use as guides or as just information upon which to determine their sentences. And I spoke with Marco Van Huigenbos about this and asked him why he did not comply or why he did not participate in this interview. He told me that he had previously spoken with Alex Van Herk about Van Herk's interview with his separate probation officer. And the nature of the questions, according to Marco Van Huigenbos, were too invasive, too private. Questions about religious perspective, questions about political and philosophical orientations, questions about field staff, and this the state's business to not engaging in it. He further told me that he has expectations that he will face more severe consequences, that's his word, from the judge, given that his lack of compliance may be interpreted as intransigence or recalcitrance or obstinance, but we'll see how that plays out in terms of his anticipation of suffering worse consequences by angering the judge by refusing to do the interview to create this PSR.
Yeah, I mean, listen, Rebel News, I think, has been more closely affiliated with all these truckers than anyone else. We were reporting on the scene. We were embedded in that blockade 2.5 years ago. We crowdfunded for the men, not just for the Coutts Three, but I think we had 55 other people who had some sort of ticket or minor charge emanating from it. We chose not to defend the Coutts Four because of the accusations of serious violence, conspiracy to commit murder, although we later set up a special crowd fund for one of the men. I guess what I'm saying is that Rebel News and our friends at the Democracy Fund have spent an enormous amount of time defending these men, promoting these men, and crowdfunding the legal defense of them. So we're obviously very sympathetic advocates for them. But I have to tell you, nonetheless, the idea of not filling out a pre-sentence report sounds very counterproductive to me. If the idea is to dispute the conviction, then the thing to do is to appeal it. If the jury got it wrong, if the judge got it wrong, then appeal it. If the judge gets the sentence wrong, then appeal it. But to accept the jury's conviction, which these men have done, and then to not participate in a pre-sentence report, which I've got to think could only help the men. I find that worrying. And if there was a particular question that someone didn't want to answer, don't answer it. I'm nervous when you tell me that, because I think, although I don't know the judge in question, I know a little bit about him. I've got to think that this looks like intransigence and defiance. And that actually is a factor in sentencing. We all know that. We know if someone is, remorseful or repentant, things go easier on them in a sense that you can understand why. If someone is defiant till the end, well, the place for defiance is when you're fighting the trial, not afterward. I'm very confused by that. And I hate to say it, but I think it could wind up getting Marco Van Huigenbos a jail sentence. And if a jail sentence was already in the wings, a larger one. I don't understand that. And I can't imagine that his lawyer, funded by the Democracy Fund, would have advised that. Listen, I hope he's not punished harshly, but I think this is poking the judge in the eye with a stick.
I had a very similar conversation with him, and I echoed a lot of what you just said. So we're actually of one mind on this. And I sort of asked about the strategic implications of this decision to not comply in the interview to create this PSR. And I also offered him the idea of not answering certain questions that you find invasive, but perhaps complying or answering others that you find innocuous or acceptable. And if I can just speak for him or relay what he communicated with me as accurately as I can recall, it's just that he thinks the entire process itself is invasive and wants to bring attention to it. Moreover, you said it a moment ago, and I said something similar to him, that this PSR ostensibly could help him if he's able to describe himself in a way and just present a picture, an accurate one, of course, in which you can obtain leniency from the judge, given his discretion, understanding of your scenario, your circumstances, perhaps your mindset. And Marco Van Huigenbos's genuine perception is that this PSR will only be used to hurt him, given that if he answers these questions honestly in terms of his political perceptions, he does not change his point of view that the protest itself was a justifiable exercise of civil disobedience to oppose this entire so-called public health apparatus that they were in opposition to. So his point of view is that the PSR would only be used to undermine him. And he's basing that on what he understands has already been asked of his fellow co-accused convicts, in this case, George Janzen and Alex Van Herk.
You know what? I'm not going to pile on the guy because I think he's facing prison time. If you look at the conviction of Arthur Pawlowski for inciting mischief, now his case, that's the Christian pastor who came down, gave an 18-minute sermon to the men to encourage them. He was convicted of under the Criminal Code of inciting mischief, and his sentence, I believe, was for time served, which I think was something like 52 days, if I'm not mistaken. So Arthur Pawlowski left the court immediately and went home because, like I say, he had already served his time. And so the punishment meted out to him didn't require him to serve more. But that's a precedent, a very close precedent. It was about the Coutts blockade, about mischief, very, very similar to what these three men are facing, at least on in the name of the charge and the gravity of the charge. And I mean, I suppose 60 days or 50 days in prison is not the end of the world, but I mean, I certainly would want to do it unless I absolutely had to. I just don't quite understand it. And listen, I hope it works out, but I don't know if being defiant when you've already accepted the conviction is that it seems like out of order. If you don't think you did anything wrong, then appeal. If you accept the conviction, then do your best to, make it easy on yourself and your family. Listen, I'm not the guy in the who's waiting in the wings here. I'm not the guy whose liberty is at stake. So I'm just an armchair quarterback here. But I find it confusing, especially since the lawyers that we've mustered for these three men are excellent. And I've just never heard of this being done ever. The opposite. When I know people who are on occasion convicted of crimes, they want to get letters of reference. They want people in the community. Yeah, they want people in their church to say this is a God-fearing man who does good deeds every day. You want to be able to marshal your friends and family and everyone you've ever done something good to put in a word with the judge. But what can you do? It's let me say this. Marco Van Huigenbos is the captain of his own ship. He's conducted himself for 2.5 years as a very public advocate. And I suppose there's some poetry of him finishing things up as a defiant advocate. I just certainly hope it doesn't yield a longer conviction. And I guess we'll see. These are three severely normal guys who've never done a criminal thing in their life. And in their hearts, they don't believe they did anything criminal. I get it. I don't believe they did anything criminal either. That's why we were such passionate advocates for them and crowdfunded the lawyers. Listen, that's Alberta for you, especially Southern Alberta. Self-styled guys, mavericks, freedom-loving guys who are defiant and skeptical of authority. So perhaps it's a poetic ending. I just hope it doesn't put them in jail too long. That's all.